Happy New Year and good morning, everyone. And I have a script that I need to read at the beginning of our meeting, so I'm going to start it, and then David Fye will finish that script. So I'm going to just start right away. Hello, I am Laura Shaughnessy and serve as chairperson of the Professional Counselor Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting and at this open meeting that is being conducted remotely by conference call and other electronic medium. Kenneth Huey on here?
Here.
Oh, there you are. Thank you. And Bob Kircher. Here, I saw him wave. Can you unmute yourself and say here so we can hear you?
Here.
Thank you so much. Ken and Ola, is he on yet?
Here.
Thank you.
I'm here, but I'm still on the phone.
Okay, we hear you. Thank you so much. Gary Price.
Here.
Elaine Tachik.
Here.
Thank you. I also see Andrew Secor.
I'm here.
Hi, thank you so much. And Leslie Sewerster will not be present at this meeting, as I understand.
She's going to be joining in a little bit.
She will be joining. Okay, good. I note the following staff members are also present: David Fye, Leslie Allen, and Ashley Van Busker. Assistant Attorneys General Janet Arndt and Lane Barnard, who are assigned to the board as general counsel, are also present. David Fye will now read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act does not require advisory committee to provide public comment or answer questions from individuals. There will be no public comment at today's meeting to ensure adequate time for the items currently on the advisory committee's agenda. Because we're conducting the meeting remotely, the public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because the emergency declaration that was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns, as the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to the meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of COMA are not suspended. As such, we'll be conducting this meeting pursuant to COMA and KAR 16-20-1 concerning compliance with the COMA during an existing emergency disaster declaration. On January 29th, 2021, we sent notice of the advisory committee meeting to all individuals who have requested notice of the advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov, and you may obtain a copy of the notice at that website. An agenda and other meeting materials is posted to the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line "Request for an Agenda," and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the advisory committee, staff, or presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting will ensure microphones, phones, or other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the advisory committee votes, and each advisory committee member will vote when their name is called. The chairperson will announce the result of the final vote. The advisory committee lacks authority to delegate a member of the committee or staff to sign any binding document on behalf of the board. Thus, no statement or motion will be made. A recording of the meeting will be posted to the board's website. The advisory committee has the following items listed on the agenda: new advisory committee meeting orientation, executive session, approval of minutes from the last meeting, executive director's report, update from the board meeting, and planned committee work for the upcoming year. The advisory committee's agenda includes an executive session. If the advisory committee elects to go into executive session, the advisory committee will follow the following process. First, the advisory committee must be in an open session before going into an executive session. Then an advisory committee member must make a motion to recess for an executive session that is seconded by another advisory committee member. Each advisory committee member will then vote. A majority of the advisory committee must vote in favor of the motion to exercise the executive session. The chair will announce the results of the vote. The motion must contain a statement of justification for closure and the subject to be discussed pursuant to KSA 75-4319B, and the time and place for the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume through the conference call. The complete motion for the executive session will be recorded in the minutes. And just to note, the executive session is on a separate phone number that was sent to you over email on Friday. The complete motion for the executive session will be recorded in the minutes.
Thank you. The meeting is now called to order, and the advisory committee will begin its discussion of the first item on its agenda. So the first item is new advisory committee member orientation with Janet Arndt. And Janet, do you want to take it from here?
Be glad to. Thank you. My name is Janet Arndt, and I'm Assistant Attorney General. I've been with the Attorney General's office since May of 2007. I was not assigned to the BSRB board, though, until about July of 2011. So I've been with the board for a little bit, but it's still always a learning experience. The board decided that typically we do training. We hope to do it every year for board members. But this year we've had several new board members, so decided to go ahead and do the board member training. But in addition, the board decided that because we also have committee members and we weren't aware that they had ever gone through the training, the board wanted them to go through the training as well, so that they're kind of more familiar with what the board does. And so because you help advise the board, then that will kind of help you know to how the board has to go about doing their business and understand what's going on. Most of you are going to be licensees, so you already understand the licensure process. And that is pretty much the same for most professions. Doctors, nurses, real estate brokers, barbers, police officers, they all have some type of a licensing through state agencies, which means that the agency then is responsible for regulating those individuals to make sure that the public has competent, ethical professions to help them. What we do is we call an agency a creature of statute, and that's because it means that you have been created by the legislature through the enactment of statutes. So that means that you have been set up through statutes that are called your Enabling Act. That's where it sets out how many board members there will be on the board, how they're created, what the qualifications are, how long your term is, what your powers are, and that type of thing. There's also going to be licensing acts. That's for all the different professions that BSRB regulates, such as you'll have, for this one, professional counselors, psychologists, social workers. There's all those different acts, and the board's in charge of implementing that. The biggest thing that you need to take away from this is because you're a creature of statute, it means very simply that you can only do what a statute says you can do. A lot of people, when they get on the boards, they think that, well, what statute prohibits me? And that's not the question. The question is, what statute authorizes this action? So if you don't have a statute to do what you want, you probably won't have the authority to do it. So that's what you need to keep in mind. In addition to statutes, there are some constitutional limitations, such as equal protection and due process. So those are other things that you need to be aware of as you go through and make decisions. There's other things such as freedom of speech, rights of privacy, rights of association, unseizable search and seizure, and then whether or not vagueness. Usually you're going to see vagueness when you are when the board is working on regulations. You have to make sure that people can understand it and that it's not too overbroad. The legislature does keep its power over the board. So it's not that once you've been created that you will always be there. The board can basically do away with the enabling acts, and by doing that, that eliminates the board. They can also, if they decide you need more authority, they can enact a statute to give you that authority, or if they think you've gone too far, they will go in and amend a statute to limit it or just take it away. So that's one of the things you always need to be kind of cautious of. And that's why we say always make sure you have a statute that gives you the authority and see if there's any limitations on that authority. Another thing that boards struggle with is whether what they can do is discretionary or mandatory. Discretionary, you're going to see language as the board may do this. That means you have discretion and you need to exercise the discretion. You cannot do a blanket rule that says if this, then that. May means you have to look at each case on its own merits, on its own facts, and arrive at a decision. If it says shall or must, then you're getting into language that is mandatory and there is no discretion. So it's like if it says the applicant shall pay a fee, then that means you don't have any authority to waive a fee. So the whole purpose when you're looking at anything that you do, the whole purpose is to see what will protect the public. How does this help the public? You are not here for the licensee. You are here for the public. So it's not you're here to protect the licensee or to make their life easier. It's to protect the public. And that's the main goal that you want to keep your focus on. The licensing will grant licenses to those who meet the qualifications that are in the statute. And through a disciplinary process, they can discipline it by conditioning it, limiting it, revoking it, or suspending it. Or putting some other type of sanction that's allowed by the statute. Kind of going back to your government classes, an administrative licensing body is sort of like you have all three branches of government: executive, judicial, and legislative. The executive function is basically when you are carrying out your duties to enforce or administer a licensing act. And in doing that, you follow the Kansas Open Meetings Law to make sure that you conduct the business openly. So that's why you have these meetings. They have to be open. They have to follow COMA, which is the Open Meetings Act. And you also have to comply with the Open Records Act. And we'll get into details of those two acts a little bit later. Your judicial authority is sort of, it's called your quasi-judicial hearings that you can have. So if you were to deny an application or to take discipline against a licensee and they want to have a hearing, then the board has the authority to conduct those hearings and to make findings of facts and conclusions of law to decide then what the ultimate decision should be. So most of the agencies that do have quasi-judicial authority are under what's called the Kansas Administrative Procedures Act, which is CAPA. And that's basically to achieve uniformity among all the agencies that have that. It's a due process protection. Your legislative authority is going to come from being able to enact regulations, because once you have followed all of the requirements of the Rules and Regulations Filing Act and it gets published, that regulation will have the force and effect of law, just like a statute does. So we'll go through the process or touch upon it since I don't know, perhaps you might assist with maybe helping write regulations. That's kind of why, so you can see the process that it goes through, because it is a very time-consuming process and it needs to be, because it is, like I said, it will become the law. And so people need to be have that input into it. As I was saying, the board implements and enforces statutes and regulations. You will also have internal policies. And you kind of need to know what the difference is between the statutes, the regulations, and the policies. Like I said, statutes are done through the Kansas legislature. They have a bill, they both pass it, it goes on to the governor who signs it, it gets published. Most statutes are going to become effective on July 1 of that session year. However, the legislature can give it a different effective date. A lot of times you'll see statutes that will become effective on the date of publication in the Kansas Register. So it may become effective perhaps in March or April rather than July. Sometimes they will delay its effectiveness to January 1 of the following year. And that's usually basically because it's typically a new act, and it's to give the board the authority to gear up to get ready to start handling that new provision. So you have to look at the statute to decide when it's going to be effective. Regulations, I said, are basically, those are going to be adopted by the board, and they are not meant to give you whole new powers separate from the statute. They are basically to carry out or implement or administer or enforce a statute. So you can't create new law, you're working with the law there, and it's sort of like putting meat on the bones, if you want to think of it that way. Another way that I kind of, an example I give for a regulation is, I kind of took it off of my predecessor, embellished a little bit, but a regulation is, think of it, you have to stop and think that the legislature built a corral, okay? And so it's got this nice fence around it. And then they said, okay, you can put thoroughbred horses in your corral, and you can develop regulations to decide, you know, what qualifications those horses have to be able to come into your corral, the thoroughbreds. Let's say it's a thoroughbred horse. And you do that. So you say what kind of training they have to have, some kind of certification, whatever, to get into that corral. And then what kind of training maybe they have to keep having to stay in that corral, and how if they break certain rules, you get to throw them out of the corral. One day someone sees a zebra and they think, okay, that's a really cool looking horse, I want to put a zebra in my corral. You can't do that because your authority that the legislature gave you was to put thoroughbred horses in there, and a zebra is not a thoroughbred horse. That's kind of what it's the regulation is about. And you've got it, your regulation, you can broaden and put more structure onto the statute, but you can't go beyond the authority that it gives you. The Rules and Regulation Filing Act has procedures that it has to go through, and that's basically to make sure that all of the regulations have the same format, have the same type of language, and go through the same process. When you're going to look at a regulation, there's some steps you want to go through. And one is, do we really need a regulation? Is this something that you need to be able to enforce? Because it does become the law. So if it's not something that you need to enforce to address a problem, you may not need a regulation. One of the things you don't do in a regulation is to just repeat the statute. And you also don't put any language in there that's self-directive, which is to say that you're telling the board what to do. Like, upon the receipt of an application, the board shall do X, Y, and Z. That's self-directing. The regulation is to tell the people that you are regulating what they are to do. You also don't just put information that's nice to know. That's something you could put on your website, but it doesn't belong in a regulation. When you decide, okay, yeah, we need a regulation, then you're going to have to look and see if you have an authorizing and an implementing statute. And that gets kind of confusing for a lot of people. The authorizing language we're looking for that is the statute says the board is hereby authorized to implement, administer, and enforce the provisions of this licensing act. That's pretty broad authorizing language. Sometimes it's more specific. It'll say that you have the authority to adopt or regulations to enforce this particular statute and only this statute. So you have to look and see what you're authorized to do, and that limits you as to how far you can go. Then the other thing is the implementing statute. It may or may not be the same statute as you're authorizing. Typically, it's not. And that is basically that your regulation is about the same subject matter of that statute. So if it's about fees, then you have to find your fee statute, and that would be your implementing statute. That's what we're looking for. If it's about, you're putting the details on filing the application, then your application statute is going to be your implementing statute. The procedure is set out in the Rules and Regulation Filing Act. There's a big manual. I've provided the link. It's out there in the Department of Administration's website, and it's pretty lengthy, but it goes into detail about the procedure, about the language, and about how they want it done. There's also an economic impact statement that has to be presented with the regulation to make sure that you're not making it overly burdensome for those who have to comply with it. If you're going to adopt any regulation by reference, which means that, say, rather than put all of this language you want in a regulation, you're going to adopt a federal regulation, then you have to attach that federal regulation with your adoption by reference. So that's, and then what happens is that you also have to go through that document that you're adopting by reference and go through it to make sure that you have the authority for what's in that regulation within your statutes. And you have to also then modify it so that it goes correctly for your agency. Once you've gone through that and done that process, then it's going to go through, it goes to the Department of Budget, it goes to Department of Administration, and then to the Attorney General's office. So each of those different agencies can review it. The Department of Budget will basically be reviewing the economic impact statement. If they agree, then it meets their approval, then they stamp the economic impact statement and the regulation. Then it goes over to Mary Greb Hall in the Department of Administration. She is the one that reviews it for format and to make sure that the language is correct and the grammar is correct as to how she wants it done. After that, then it goes down to the Attorney General's office, and the Attorney General's office has 2 attorneys that will be assigned to it to review it to make sure it's okay for legality. And we check your regulations that you've cited in your history section to make sure that you do have the authority then to do the regulation, and that there's also no constitutional issues as well with it. Once it's got all the stamps on it, then it's going to go over to the Secretary of State. They have to, for permanent reg, it's going to go to what's called the Joint Committee, which will have people from representatives from the House and the Senate who review it. Usually someone from the agency is going to be there, such as David, to answer any questions that they may have. People may want to file. It's not like a bill where people can give testimony on it at that point to the legislature. Instead, after that hearing, then you will have a public hearing with the, it's usually going to be like at the board office, and that is where people can come and provide testimony at that hearing, or they can file written testimony. Once that's done, then it's going to go to the board. The board has to decide if they want to make any amendments based upon what the Joint Committee said and what the public had to say at the hearing. If so, those amendments are made and the whole process starts over again. So that's can be kind of frustrating for staff. If there's no changes that they're going to make, then they have to do a roll call vote to adopt it. Then that roll call vote and the regulation goes back to the Secretary of State, and they publish it in the register, in the Kansas Register. Once it has been published, 2 weeks later, it will become law. And so then that's when you can start to enforce that. The effectiveness as a board member, the most important thing to be a good board member and to keep yourself and the board out of trouble is to know your laws. And that probably goes just as well, I think, equally as important for the advisory board. So Know the enabling statutes, which gives the boards its authorities, it begins in 74-7501. Then you need to read the licensing acts. For you probably need to be very familiar, this advisory one, with the Professional Counselors Act to know what it takes to become a professional counselor. Make sure that you understand what it takes, and then also look to see if perhaps there's any reason that you think that the statutes maybe need to be changed. A lot of agencies are dealing with the requirements for licensure if they need to be changed, not just this board, but other boards, changing, the number of hours or the number of practice they need to do before being licensed, those kind of things. So once you think you have them, you may need to reread them from time to time. If you've got an issue before you, you probably definitely should be rereading them to familiarize yourself so that you know for sure that you haven't forgotten something, or that you're not, wrong on something. Also reread the regulations so that you're familiar with, again, what the board has said about particular statutes, how they've interpreted them through their regulations. If you see that there's any kind of discrepancies between the way you think that the requirements are in the statutes or the regulation with the way it's being done, you always, should ask questions about that. What we don't want to hear, if there would ever be a challenge, is that this is the way we've always done it. You always need to be on the lookout to make sure that things are appropriate and being done appropriate, and not like, well, it's been smooth sailing, so why should we change it? You need to also, if you've got documents on your website, pull those down, make sure they're current. I know there's one document on your website that's not current. It's about 3 executive directors behind. Information on it might be current, but it's not. So, it's like I said, it's just making sure that everything is current and up to date and everything's consistent and nothing, that everything is going to run smoothly. If anything is outdated, don't be afraid to recommend to the board that maybe you need to modify the regulation, or ask the statute to be amended, or to get a new statute, maybe even repeal a statute. That is one of the things. There's a lot of movement with the legislature to get rid of outdated statutes. And so that's something probably, that it would look good if you would recommend, hey, we don't need this statute anymore. It doesn't work for us. It never, we don't use that. Like before CAPA, the Administrative Procedure Act, each licensing act had its own procedures on how to conduct hearings. Well, when they put you under CAPA, you don't need those, but some agencies did not get rid of those old statutes. So that's an example of statutes that could be repealed. But when you go through your statutes and your regulations and your policies, always remember that you're there to protect the public. And that's your discipline is one way, and who should get a license is one way, but you got to really be on the lookout to make sure you're not trying to be vindictive, or that what you're trying to do, like for a discipline, is disproportionate with what actually happened. The harshest sanction, which is revocation, is typically something that you only want to do if the licensee has done something really egregious, or they've had multiple violations, that it didn't result in 1 or 2 minor violations. It was several violations, and some of them were very egregious, or they have a history of repeated violations, but yet somehow they don't quite get what they're doing wrong, and they just keep repeating them. It's like if they can't learn from their actions and what's happened, then maybe that's a decision that they no longer should be licensed. But remember, the overall reaching then is to protect the public, not the licensee. That's sort of the other end of the spectrum. Conflict of interest is something you always kind of have to be aware of, making sure that whatever you're doing, you don't have any type of interest, whether it's financial, personal, direct, indirect, with what you're doing. As being on the board member and even being on the advisory committee, we're realistic that you probably wear many hats. You're not just there as a as a board, solely a board member. Like for instance, you're there as a licensee. So you have a licensee hat that you wear. You may be an educational instructor. So you have an academic hat that you wear. You may be an employer who hires licensees. So you have that hat that you wear. You may also belong to a professional association. So that's another hat that you wear. When you come to the board, you need to put all those other types of hats aside and leave them at home, which being remotely, it's kind of hard, but you need to put all of those aside and wear only your board hat, and remember that what you're doing is to protect the public and not what all of these other interests may help them. And sometimes that gets kind of difficult. I think for some board members, it's especially when they first come, because they have maybe been very active on a professional association, and what the professional association is trying to accomplish, they want the board to do. And you can't do that. You have to take that aside. And if it means that you can't do both and be impartial about that, then you may have to think about if one of those hats needs to go. So that's the other thing. And you're going to get phone calls from licensees about this problem and that problem. And you have to remember that, again, you are not there to protect that particular licensee or licensees in whole. So, you can say, that's fine if you feel that way, but if you have a concern, you need to bring it to the whole board. But again, you're not there to protect that person or to give that person advice or to tell them this is what you need to do. Personal conflicts could influence a decision, and a lot of times it can be as easy as it's more of your career advancement or monetary advancement, such as if you would deny an application to someone who would be, especially if you're in like a remote area where there's not a lot of other licensees. So denying a license would mean it wouldn't upset your business. You wouldn't lose any clients. You might even get some more clients. Another one might be that a licensee is the son of one of your neighbors, your best friend, and you can't be if you think you may be influenced about that decision on what you should do with that applicant, or if they want you to vouch for the applicant, then you may need to recuse yourself, because if you can't be set that aside and vote on what is really going to protect the public, then that is something to be thinking about. Another one might be that has to do with you have a supervisor. And the board is thinking about taking discipline against one of the employees. So, you kind of have a problem there if you are sharing the same supervisor with the person that is being considered for discipline. Confidentiality is a big thing. Whatever, it's sort of like, what they say, what happens in Vegas stays in Vegas. This is sort of the same deal. What happens on the board, especially when you're dealing with confidential information, it could be during executive sessions, deliberations, or information that's on an application, that needs to be kept in the capacity of the board. And your confidentiality stays with you even after you have left the board. So once you get off the board, doesn't mean that you're free then to start telling everyone what happened while you were on the board and things that, well, this is why we voted this way because this is something you didn't know. You can't do that. If it was confidential while you were a board member, it remains confidential afterwards. Executive sessions are things that are taken during the open meeting, and it's just to allow the board members to have a discussion about something that the legislature has said is confidential and that you can discuss in a closed session so that the public cannot hear those discussions. Typically, for this board, because the reasons you can go into executive session are set out by statute, they're pretty limited. And for this board, the ones that you see most often are going to be for personnel matters. And of course, as an advisory committee, that probably will not affect you, but it will for the board members who are on the committee. So it may be, from time to time, you'll be taking an executive session to discuss those. The other one would be, the other reason that is more common is to have attorney-client confidential discussions. And that way it protects the attorney-client privilege. So that, again, it's for those people that the client and the attorney to discuss the subject matter. It could be any number of things, perhaps to discuss ongoing litigation, to discuss interpretation of a statute, of a regulation, those type of things where you need some legal advice before you proceed. Or the attorney needs your decision on how you want to proceed before they can go back in court and present your viewpoints. The reason that you don't, especially an attorney-client, that's very important, because what will happen is if you go out and discuss that confidential information that you received, you could be exposing yourself to a open meeting complaint. Because if you were going to go out, have an open meeting and discuss the information that's confidential, but then yet go back out and talk about it, someone's going to say, well, why did you take an executive session if you're going to come out and discuss what you just, and tell everyone what you just did? And so that's going to result in the open meeting violation. So that's one of the reasons, and we're going to get here later to show you why that has impact for you personally. That's one of the reasons you don't want to do it. But again, there's a reason you do have the confidentiality, because you don't want that information getting out there, because it may be that someone then will take it wrong. You could end up in a lawsuit. So it's to protect you. Deliberations are also another thing. Deliberations, though, are a little bit different. Again, all of the hearings right now you have for licensure are under CAPAs, and CAPA does allow you to have your deliberations are separate. They're not open. Also, if by some chance you would have to have a hearing that is quasi-judicial, then you can use the quasi-judicial deliberation under the Kansas Open Meetings laws to get about that. But as an advisory board, you do not make quasi-judicial deliberations. Quasi-judicial deliberations means that you have to make findings of facts, conclusions of laws, and a decision. And as an advisory board, that really does not apply to you. So I can't imagine that you would be really needing to have quasi-judicial deliberations. The next thing would be that if you are, for those board members who do hearings, which we have a few, is ex parte communications. Ex parte communications is really kind of a due process thing. It's to make sure that one side isn't, you're not having confidential, you're not receiving information that the other side is not privy to. Both sides, if you think of yourself as a judge, it's just like in a hearing in district court. The judge can't have a conversation with one party, if the other party's not there. That's the ex parte. And it's the same thing here. The licensee cannot come, like if it's for an applicant, they can't come to you and say, oh, by the way, here's something else I want you to know about me that's not in my application. That would be the ex parte communication. You need to basically stop that. If you do have an ex parte communication, then under the Kansas Administrative Act, you have to put that on the record. You have to notify people that you've had the ex parte communication so that they know what it is, know what the extent of it is. And then what could happen, that other side could say, you've had an ex parte communication, I want you off of the case, and they could ask to have you removed. So it's best to avoid the ex parte. And it can occur even innocently. You could be at an association meeting and just bump into someone and not even be aware that they have something pending, and they start talking to you. And if that happens, you just need to shut it down as quick as you can. Just tell them, I can't discuss this with you. I'm sorry. Also, it can occur too by even not just the party, but the party's attorney may contact you. Hopefully, most attorneys know that they cannot do that and will not do that. So like in CAPA, you can communicate through email. So if you communicate with one attorney that's representing them, then you need to communicate with the other attorney. And those are the attorneys in the litigation. I'm not talking about if you want to ask like myself as general counsel, that's fine. That would be asking your attorney something. But to ask the litigant something, then you have to go to the litigation attorneys and have both of them in there to avoid that ex parte communication. Professional activities, again, the same, we kind of touched upon that. You've got roles, you may be very involved in professional associations, but you just cannot use your position with the association to try and further those interests with the board. Again, and if you go to meetings, make sure that you don't trigger a COMA violation by, especially if there's several board members there, don't start discussing board business with the other board members. One of the other things that's just kind of general overall thing is a lot of times you're going to be authorized. What's your opinion on this? Or if you go, especially if you're going to go speak at something, say you have your own personal interest and it is pending before the local government, you need to make sure that, if anyone asks, that you are making sure that they understand that you are speaking for yourself. You're not speaking on the board's behalf. Sometimes even you may want to go speak to the legislature on a pending bill. So that's where you have to say, yes, I'm on the board, but I'm not here on behalf of the board. The board has not authorized me to make any types of opinions. What my statements are expressly those of myself and not the board. Okay, get into a little bit more of the nuts and bolts then, the Open Meetings Act. You are subject to the Open Meetings Act because you are a state agency, and that's the board. And then the advisory committees are also subject to the Open Meetings Act because you've been created by the board and you receive funding from the board. And you think, well, I don't get any money for it. Well, that's not it. You're getting help from staff. So that's the funding. And you get whatever you need to do your business through the board. A lot of, I think there were some board members who didn't think that the advisory committees were subject to the open meetings law, but they are. So make sure that you understand the COMA and that you comply with that, which means that you can't, your meetings have to be out and open, and it's been kind of difficult. Typically in the past, before we had the pandemic, they're held there at the board office. People went to the board office to have them. The public would go to the board office to observe them. With the pandemic, that's not been really feasible because of all of the state buildings being closed for a while, not open to the public. And then we had social distancing, and the boardroom wasn't large enough to social distance for everything. And so that's why we've set up like remote meetings, which is what we're having today. So people can appear remotely by video conference or by telephone conference, and that's how you conduct your meetings, and that's how you have your discussions. You can't have your discussions, private conversations or emails, telephone calls. It has to be where it has been, notice has been given to those who want it, and that so that they can also observe. So it's, like I said, so that's why, you can conduct it by telephone or any other active communication. So that's why I say you don't want to start picking up the phone to have conversations and then they call someone else and say, hey, I just talked with Gary. This is what he and I talked about. And what do you think? And then it keeps going until you've got a majority. That's how you get in trouble having telephone conversations when it should have been through an open meeting. The same thing with emails is when you have an email that goes out to everyone and it said, this is for your information. Well, rather than just reading it and dropping it, people hit reply all and start commenting on it. And then it keeps developing. And then we've got a problem. So you don't want to have those type of communications. If you need to talk to it, you need to ask Dave to set up a meeting for the whole group. And it has to be a majority. It used to be that it was a majority was for a meeting was a majority of the quorum, which would make a very small number, but they changed it. So now it's just a majority. So if you had like 11 members under the old one, a majority of a quorum, let's see, it'd take 4 people instead of 7. So, and that could be very problematic, especially if some of you were all together at an association meeting and were there. The majority of a quorum could be reached pretty quick. So it's looking for a majority, and you're there. The purpose of it is that you're discussing the business affairs of the public agency. So those are the 3 big elements that you want to remember. You need to, if you're going to be discussing the business affairs, then you probably need to be setting up the open meeting through Dave. It doesn't really matter what you call it. A lot of times people say, well, we're going to have a work session or a retreat. You can call it what you want, but if you're going to be discussing the business of the board or of your advisory committee, then it's a meeting and you've got to follow COMA, which means that COMA does require notice to those people who have requested it. And so consequently, I think that's why you'll see Ashley sends out that great big notice that tells of all the meetings that the board's having, so people know that and can attend. And without getting that notice, then you've got some issues. A discussion doesn't mean that you did anything, that you made any decision. It's just the discussion. Cora does not require that the notice of the meeting has to be published. I mean, typically you're going to see it on the board's website, but that's not a requirement. The big requirement is that if someone requested notice, that you send the notice. They can request it verbal or written. It's best if they provide it written so you know exactly which meetings that they want to attend. But the notice has to give them the date, time, and location where the body's going to hold the meeting. And if it's not going to be held in a physical location now, you have to tell them how they can attend electronically. Their request is valid for 1 fiscal year. However, though, when that fiscal year comes around, you can't just stop sending out the notices. So typically what the board will be doing is probably in June sometime, they send out an email and says, hey, if you want to continue getting these notices, you have to tell us. If not, we're going to drop you off of our notice list. And basically that's required, because you're going to see a lot of agencies, they have several hundred people who have requested notices. And so it's to keep their notices current, to make sure that they're just sending them out to the ones who want it. And so it is a way that you can kind of call out and keep everything current. The other kind of misconception that board members have, especially new ones, it's like, well, how do we conduct the meeting? Do we have to follow Robert's Rules of Order or some other type of procedural thing? And no, the COMA doesn't have anything about how you conduct it. That's up to you. Most agencies just have a very, they don't have any formalistic type of things. It's just typically they will have some type of agenda. They'll have someone who presides over the agenda to make sure things keep moving along, and make sure that, motions are made, discussed, seconded, and passed upon. When you follow Robert's Rule, there's a lot of technicalities, and my advice has always been, don't adopt the Robert's Rules. Most people don't know it. They don't know how to follow it. It's not law, so it's not legal advice. I don't know. I can't tell you anything about Robert's Rules because it's not a statute. It's not a regulation. It's not law. And so they have to decide then what's a Robert's Rule of Procedure. And like I said, it gets confusing. It also limits you, like if someone makes a motion and they vote a certain way, then they can't make another motion, or a motion can't be made again. And that's not really what you want for this type of board. You want to be able to have some flexibility to maybe something, to maybe to go back and to relook at something that you did do because new information has come to light or someone misunderstood something. So you may want to go back and open up that discussion. So it needs to have flexibility. You're not required to keep an agenda, but if you do have an agenda, you need to make it available to people when they request it. You also are not required to have minutes unless you take an executive session. They amended the thing, that's always been in there, but they made it a few years ago, they amended it to make it even harder. It's basically the motion has to be kept done verbatim. So that's why I typically ask like Dave to let me know when there's going to be an executive motion made, because then I can help, because there's requirements that what has to go into that executive session motion. And I can help you with that to make sure that you have that. And then you have something to go with for your verbatim to put in the minutes that you had an executive session. But again, you have to, it has to be a formal motion and you have to be in your open meeting to make the motion. And it has to have a statement that describes the subject, but you want to make sure that you don't go into so much detail that you are revealing confidential information, such as if it's going to be about personnel, you don't want it to say, well, we're going to go into an executive session to discuss firing Leslie. You know, you've let out, you've probably then aired, you know, created privacy issues. So you don't want to go that far, but you do have to say to discuss a personnel matter involving, conduct or something like that of a employee who's not appointed and so forth. There's a language in there that you have to follow. The justification, that's what's in the authority that you have in the statute to close out the open meeting. And like I said, for you, it's usually personnel or attorney-client privilege. And then you have to state how long you're going to be gone so that they know the time and the place you're going to resume the meeting. And then that is in the minutes, and it has to be permanently, those minutes are permanently retained. So you can no longer have them on your disposition record. They're permanent. Some of the complaints that people can make open meeting complaints to the Attorney General's office. The ones that we see most common are that, one, you took executive sessions, the motions weren't proper, that you had non-board members in there. And a little bit about that. Yes, you can have people in there that are non-board members, but there you have to be able to justify why there's in there. Like if you're going in for a personnel issue, it's going to be very common that you will bring in the executive director because he's the one who's in charge of the personnel. He's the one who probably knows what the facts are about that staff member, that type of thing. It may be that you need people in there to give you a factual basis. So you invite them in, they tell you what they need to know, and then they leave. And that may be where you've got several employees involved, and you have to have them come in one at a time to tell you what they know about the issue. It's same thing, and you may be going in for attorney-client consultation. Oftentimes your client will include staff. So it's very common that you will see like David or Leslie in there because they are part of the client circle. Perhaps they need to know just for the day-to-day operations as to what to expect or what the issue is so that they are aware of it and don't, do things differently in what needs to be done. Other things is that you don't return on time. You say you're going to be done at 10:15 and instead it's 10:20. And then again, one is that you start talking about what's in executive session. The serial communications, those are what we were talking about, like where you make a telephone call and one person says, makes a phone call then to another, and it just kind of keeps going. Another one is called a calling tree, and that might be that one person would call David. David then calls that another person, and then David calls another person. So that's one person that talks to everyone, rather than one board member talking to this one and then they talk to another one. The calling tree is another type of serial communication. And then the other one is that someone asked for notice of a meeting and they didn't get it. So that can be very problematic, and that's why you need to keep the list up to date. If someone makes a core complaint, it's a civil matter, it's not a criminal matter. Any person can bring a core complaint or file a litigation into district court, as well as the county or district attorney, and the attorney generals can also do that. The county and district attorneys and attorney general have subpoena power. Private individuals do not. Enforcement actions in district court take precedent over other cases, and they're to get assigned at the earliest practical date. Some of the remedies would be if you took action to have it voided, to stop an action, or to force you to do something, or just to declare a declaratory judgment that what you did was wrong. This is where you need to pay attention. The penalties, if there is a core violation, are a fine for up to $500 for each violation per board member. Okay. Now make sure you understood that correctly. Per board member that participated in it. So if the fine is assessed, it's not against the state, it's not against the board, it's against the board member. It comes out of your own pocket. That's why the training is so critical. So that's why you need to make sure that you don't have those conversations except for when you are in a board meeting. They can also have you ousted from office, recalled. If there's court costs, they can assess that against you and have the court cost awarded to the person who wants enforcement. This one phone I forgot to turn off. They can also, if they believe that that your defense was frivolous, not in good faith, or if the action was frivolous, they can also, like again, that's for court costs, but there's also, I believe with the attorney general, they can get attorney's fees. So if the attorney general can also do a consent agreement, which means that they investigate it, they will then make findings of facts, conclusions of law, and the standard is just a preponderance of evidence, which means that it's more likely than not that it occurred, which can be kind of low. Then they can have here though, the civil penalty under consent agreement is only $250 for each violation. They can also ask that maybe that you go to do training, and then you have to show proof that you have complied with everything that you were supposed to do. So, but you can go through and look at those. Again, that it can be kind of hefty, especially, and you would think, well, why would anyone violate the coma intentionally? Typically, it's not. It's more that they kind of, stumble and trip up. Every now and then it does appear that it does look like it's intentional, and then that's where someone's going to really get hit over the head with it. Open Records Act is the other thing, is the other act to ensure that state agencies are open so the public stays informed on what they're doing. And you may not think that you have anything, well, gee whiz, we don't have it, advisory committee, we don't have anything that's any records. Well, you do create records. Your agendas, if you are looking at any documents or having any documents that you're discussing during one of your meetings, those are records. A record is very broad. It can be paper, it can be electronic. It's anything that has to do with the business of the board that the board would receive, maintain, create, publish, anything. So it's very broad. It can capture a lot of things. One of those being that it is your emails. So whenever you are discussing anything through emails, even if it's just setting up a meeting or what you want on the agenda, whatever, those are going to be open records. So that's why I was saying don't have conversations about emails, because they can be captured. They can be then used against you for COMA violation if you're conducting business through email. So don't, it's not a good idea to do that. You want to say, well, I don't have a board email, so I'm okay. No, you're not. If you're using your personal email or your work email, you need to be very cautious of that, because they changed the law a few years ago because they found out that's what was happening to subvert the COMA. So now they went in and changed it. So it doesn't matter what server you're using to use your email, it will be under the CORA. So consequently, they also have the authority to do subpoenas to find out what you have on your personal or your work email. So you probably don't want someone coming and getting your computer to go look through all your emails or your work emails to try and decide if you discussed board business. One way you can get around that, and this is what we suggest that everyone do, is that if you ever have an email on board business that you like put CC David, then that puts it in the state server. So if they have to do a search for records, that particular email will pop up because David was included on that email. So that's the simple way around that, is to make sure that if you do have anything, that you CC David or Leslie, and then it will be on the state server for the board, and that should take care of it. So it's it may not be a guarantee, because they may think, well, I want to check to make sure that there's something that you didn't CC them on, but hopefully that should take care of it and be able to capture everything that you have in an email that's board business. CORE does require that each agency have a Freedom of Information officers. They handle all the CORE requests. They also have to have a brochure available that describes what the requester's rights are and what the agency's responsibilities are and the procedure for doing that. And then have the name and the title and the fees and office hours for anyone who wants to make a request. And they do get requests from time to time, and it can be quite onerous to go through all those emails and have to read them, in addition to all the other things that come with it. So that would be something to keep in mind, that someone's going to be looking at your emails. What I tell people is, when you're in your emails, I mean, it's very common that when you get to know people, sometimes you get kind of snarky, or you think you're making some cute, funny joke. Remember that when you put in an email, because it is an Open Records Act, if someone would request it and capture that, if there's no reason to redact something or to not disclose it, it's going to be given to them. You don't want what you have in an email appearing on the front page of the Capitol Journal or the Kansas City Star or the Wichita Eagle or any other paper, because it's happened. It can be very embarrassing for the people involved. So always try and keep your emails as professional as possible, because you don't know who's going to be reading them down the line, including me. If a CORE request comes in, I'm going to be helping staff with them and reading them. And if I can't find a way to exclude it, it's going to go out. There's just nothing else to be said. Because if you don't give it to them, that's going to be a violation. And again, it's along come penalties and everything else. One thing that if you can require, and requesters say that they're not going to solicit any kind of information, when they get the information, they're not going to use it to solicit services. And that usually comes when someone wants a mailing address so they can get a hold of all the licensees. They're not to use it to be selling them anything. The only thing is that I think they can use it to offer continuing education. People also can't get copies of copyrighted material unless permission is given. They can come read it or listen to it, but you can't copy it for them. The other thing is redaction. I mentioned that, and that's basically where you just kind of like take like a magic marker to hide the material that can be redacted. To redact it, you have to have a legal reason to close out that information. So consequently, that's why it's quite time consuming, because everything has to be read to see if it's something that needs to be redacted. When someone does make a request, it has to be acted on pretty fast. There's a 3-day letter that has to go out, which means that in 3 days you have to acknowledge that you got the request, and then tell them, when you're going to be able to, if you have it, give it to them. If not, tell them when you think you're going to start working on it. The presumption of the Open Records Act is that it's open. So consequently, it's on the burden of the agency then to find a reason to say it's closed. There's a lot of reasons to close it, like such as a state or federal law requires it. So like your social security numbers, that's federal law and state law that you're not to disclose that, and the penalties can be pretty hefty. There's fines that can be assessed of several $1,000s for disclosing social security numbers. Medical records also are something that can't be disclosed. Personnel records shouldn't be disclosed, those type of things. Personal privacy can be closed out. Those are going to be like someone's personal address or residential address, their personal email, their personal telephone number. It can be kind of a problem though when someone they don't give you their business address. All they give is their personal address, so that maybe they're using that as their business address. Well, then you've got to give it to them. It's not protected if they're conducting their business out of their home. So then the board can recover cost. It's actual cost. So if it's the time that staff has to go find the records, go through it, read it, redact it, and mail it out to them. All of that's some costs that they can do. And again, CORA is a civil remedy or civil act, not criminal. And it's the same type of people. A person, the county district attorney, or the attorney general can prosecute it. So our office does get CORA complaints saying, I asked for these records, they didn't give it, or they redacted information out of it that they shouldn't have, and you have to look at it to see. And again, there are fines that can be assessed up to, this time it's only up to $250, but you can breathe a little sigh of relief. This would be something the agency would pay, not the individual board members, because it's a board record. They can also do cease and desist from doing any further violations. So again, a lot of times, the most common complaints are going to be the costs that you were given to them, that they didn't get them to them fast enough. They think the records were there, but the agency says they're not. They didn't respond within 3 days, or they want access to criminal investigations, because those are things that criminal investigations have a lot of loopholes to go through before people can get them back. The Kansas Administrative Procedure Act, again, that is not creating any substantive law. It's creating procedural law. It's to basically give people due process. There's constitutional due process and there is statutory due process. The CAPA is the statutory due process. And if you comply with that, you're probably not going to have a constitutional due process violation. We do have an AG opinion out there. It's number 2014-07. It was requested because there's always some confusion about when are we under CAPA, when are we under COMA. It used to be there were old AG opinions out there that said, well, when you're doing anything under CAPA, it's really done under COMA, and so you got to follow the COMA. But they made, in 2009, they made some changes. They did say in the hearing statute that when you have some statutes, your preliminary, your proceedings, and it says for those, you don't have to conduct a hearing under this statute, which means you can have them closed. And then in the hearing statute, they went in and said a hearing is not a meeting. And so that's why we determined that it's no longer correct to say that when you're under CAPA, you're under the open meetings law. They're basically exclusive. So you're either but to be under CAPA, you have to have a statute somewhere other than CAPA that says it applies. So that's why you're going to go to your licensing act and see, do we have a CAPA statute? And all of your licensing acts do have a CAPA statute. All of them read the same except for one, and that's the behavioral analyst. It reads different, and that's because that's another story. I see with Leslie laughing. She knows what I mean, but it reads different. But everything else means that from when the moment an application is filed or a complaint is filed, that you're under CAPA. So you don't have to have an open meeting to discuss an application or to discuss the complaint. The only time you're going to have to, and it's open to the public, is when you are having a hearing, but you're still not under COMA, so you don't have to give them notice because it's not a meeting. The only people that have to have notice are the parties that are involved in it, or if any intervener has come in. But if a member from the public wants to observe it, you have to allow them to observe it. You can't close it out to the public for the hearing, but you can close out other things. CAPA doesn't require any kind of meetings or an agenda because you're basically looking at each individual matter. So that's why it's not really about the regular overall business of the board. It's about an individual's due process rights. And so if anything comes out of that, it's going to be like a summary proceeding order, or consent agreement, or a final order. And those are your documents that come out to show what the board's decision is going to be. Most often, the way the board does their applications, they will have to go to board members. Before they had their changes in their CAPA provisions, a lot of these things were under open meetings laws because they didn't have a CAPA provision. And sometimes they sent applications down to the advisory boards, but under CAPA, only board members can hear them because it says presiding officers have to make these decisions. And to be a presiding officer, that's statutorily defined, and it's going to be a board member or someone from the Office of Administrative Hearings. So it's going to be board members who have to look at that and make those decisions. Typically, the staff's going to gather everything that the applicant gives them and forward it to the board members who are going to be the presiding officers, so that then they can deliberate and then make a decision on each application. They can grant the license, they can limit it or restrict it, whatever they think is necessary to protect the public. If they do anything other than give them a full license, then that applicant has the right to have a hearing on whether any limitations they put on there are, need to be changed or should be changed. So that CAPA creates the framework to do all of that. But once you do give a person a license, then they have a property interest in that right, or in that license. That's why you can't just go in and take away that license or do anything to it without following CAPA to give them their due process rights. So that's why, the due process is that you give them notice that, hey, we're going to have a hearing on this. Here's the date, time, and place. Here's the issues. Here's your presiding officers. Here's the names of the attorneys, and that type of things. There's things that have to go in the notice so that people are aware of what's going to happen at the hearing. Discipline's a little bit different. On applications, board typically does not do investigations. They may ask more questions or ask applicants to get more information if they think there's a deficiency, that they don't have everything they were supposed to provide. But that's not really an investigation. That's making them provide a complete application, which is what they're required to do under the law. For discipline, that's different, because then that's becoming the board taking action. So now the burden is on the board to prove that they violated a statute or a regulation. And to do that, they will typically have to do an investigation, which means they'll contact the licensee to get their side of the story. They may contact the person who made the claim to get more information to them if there were witnesses to get a statement from any witnesses. They may have to look at a client's file. If the client made the file, they'll often get waivers from them so they can get their file from the licensee so they can see what happened. But then the complaints will go to what the Complaint Review Committee or CRC. They gather all that information. They determine, okay, does it look like there's reasonable cause to see that something occurred here, that it would be a violation? And if so, what are we going to do about it? A lot of times there's not a violation. If so, then they send the person a letter and saying, you know, they explained this, when they've looked at it, they determined there's nothing to be done here and we're going to close the case out. That may make the person who complained a little mad because perhaps they don't understand what happened. But if they do decide that, yeah, there is something, a probable cause here to show a violation, then they have to decide what to do. They're going to maybe have their disciplinary counsel draft up a warning letter saying, you know, it looks like you did something wrong, but you rectify it. You knew what you did was wrong. So this is a warning letter to sort of like, you know, be more aware of what you're doing. If they think it needs a little bit more action than that, then they can do a censure, they can assess fines. And if it's something that really needs, again, even more discipline, then they can go on to restricting or limiting a license, suspending it, or even revoking it. There are emergency proceedings under the CAPA, which means then it's used for extraordinary cases where you feel that the public's going to be in immediate danger, and that if you don't step in and do something, someone's going to get hurt or more people could get hurt. And then you do the emergency proceeding, suspend them, and then the licensee can take that directly to district court. But you still have to keep doing your investigation and finally decide what you're going to do and to have a hearing. Both parties have the right to have discovery. Like I said, the hearing presiding officers can be board members or the OAH, and the CHC will decide, or CRC will decide if what they want to do. Most often, all of these disciplinary cases, they send over to OAH for the hearing. And then that's where at the hearing, it does have to be recorded. So they're either going to have a court reporter or electronic device to record it. The board will start off, its disciplinary counsel will present evidence, then the licensee presents evidence. It's much like a case in district court where the parties present all of their evidence, make their arguments, and then the presiding officers will make a ruling. And then they do if it's at the Office of Administrative Hearings, they do an initial order. An initial order then can be petitioned for review to an agency head. An agency head would be the board members who did not hear the case. Or that were not, they would be the board members who were not on the CRC committee. Once you have sat over and presided over anything or made any kind of decision, that will take you out of being able to sit on any further proceeding in that same case. So that's why it would be the board members who were not on CRC. And they have to decide then within a very short amount of time, like 15, 20 days, to decide if they're going to accept the petition for review or deny it. If they accept it, and then they have to allow the parties to file briefs on it. And then they have to, after getting the briefs, they can have an argument if they would like, or they can just go ahead and make the decision. The decision then that the agency head makes is a final order that is appealable to district court. And if they don't hear it, then it's ready to be a final order and to go on to district court if a party wants to. Presiding officer is pretty much like what we were talking about earlier about disqualification of having a conflict of interest, ex parte communications. Or having a bias, prejudice, or an interest in a matter that it would exclude them. So whether it's someone over at OAH or someone on the board, all those same matters and concerns that you had as a board member would also apply as a presiding officer. There's also a default order that can be entered, and that would be as if you have scheduled a proceeding. It doesn't necessarily even have to be the hearing, But if someone doesn't appear and they've been given notice to appear and they don't, then they can go ahead, the other party can make a motion for default judgment. If it's granted, then basically that order is a default order, says that everything that's in the summary proceeding order or the petition that was filed, those facts are deemed true and the conclusions of law apply and the penalty is what they asked for. If that happens, the other person, the licensee, can ask to have it set aside and to get a new hearing. That can be very tough to do. You have to have really a good cause for why you didn't show up, such as you were in the hospital, you were on a car wreck, whatever the day before. That can be difficult to do. So it's very important that if there's a hearing set, that it goes ahead and that you appear. That appears even for the board. Their counsel appears on behalf of the board. So the counsel definitely needs to be there because you don't want to have your case dismissed out from under you because you didn't show up. That's pretty rare. Post-hearing matters, once that final order is issued, such as a petition for review has been granted and you issued the final order, they can ask for a motion to reconsider, which means they have to show where there's an error in the order. There's either been a fact or legal issue that is in error, and it gives you the opportunity to correct it, so that they don't have to go on to district court to correct it. But if they do go on to someone files an appeal to district court, then they're limited in what they can raise. They don't get a whole new hearing. It's just a review of the record, and they can say it was unconstitutional. They didn't interpret or apply the law correctly. The procedure was unlawful, that there weren't substantial facts to support the decision, that the agency actions otherwise unreasonable, arbitrary, or capricious. And that one is the last one, unreasonable, arbitrary, capricious, almost always is going to be in an appeal. I don't think I've ever seen a case where they didn't claim that. It's sort of the Hail Mary. So basically the whole point of this is that when you are looking at a case, you need to always be aware of how is this going to look if it ends up in front of a district court or an appellate court. Are they going to understand what we did and why we did it so that they will uphold it? Luckily, we've had pretty good, we have had cases appealed, and we've had in the last year, a couple of them go up to the Court of Appeals, and they've upheld what we did. So that's good. Some of them was kind of torturous, where district court didn't understand what was going on and they remanded it back to us. We did what they said. It went back up. They still didn't like it, but the Court of Appeals said, no, we got it right. So that's why you always have to be really careful about what you're doing and to make sure that your orders explain what you're doing, because it's the orders that they're going to be looking at. They'll be looking at the transcript of the hearing and then the orders and making sure everything was okay. The Kansas Tort Claims Act is, I believe, the last act that we're going to discuss. So yay. It's the one, hopefully, that you will never have to become familiar with, but I do like to touch upon it because if something should happen, you need to be aware of it. If you get sued, and yes, board members do get sued, advisory committees, it's probably less likely because you're not really making final binding decisions, but if you would discuss something, defame someone, even though you're not making a decision, let's say you made some bad comments at a board, at one of your meetings, then yeah, you could be sued. If that happens, then remember that you're covered under the Kansas Tort Claims Act. It says employees, but the definition of an employee includes your board members and your advisory council members. So, and it doesn't matter that you're not getting any payment or compensation for it. The basic rule is vicarious liability for any actionably wrongful act or admission within the scope of your employment, subject to any grants of immunity. So basically that's anything. It has to be within the scope of what you were doing. So that's why I say go back. This is why I try to start off the training with because we're going to go back to that very first thing I said at training. You're a creature of statute. That's your authority. So to stay within the framework of the Kansas Tort Claims Act, you've got to stay within your statutory authority so that you're not going outside of it. Because if you go outside of it, then you could lose a lot of all your benefits that come under the Tort Claims Act. The attorney's office may say, no, we're not going to represent you. If there's any immunity, you may have lost it. So that's why it's very important that you remember the Tort Claims Act goes right around back to where we started. Stay within your statutory authority. And it does, it's only what your duties as a board member, advisory board member does. So if you get sued for divorce, sorry, we're not going to help you there. That's not a board member duty. If we do defend you, there's no cost to you. But to get the representation, you have to submit a written request for representation to our office within 15 days after service of process. And with your request, you need to include a copy of the petition and the summons, and then you have to cooperate in your defense. So, if we start saying, I need this information or that information, making phone calls, make yourself available so that they can defend you. So, like I said, if there is a judgment against you, typically the state then is going to pay for that as long as it was, as I said, within your scope of your duties and you cooperated and you did not act with fraud or malice. Anything that becomes more intentional, that will take you out of it. So if you had a statute that said may and you used your discretion, so that when I say usually when you have discretion, you have to explain, I could go, here's the facts. And I can or cannot go this way. I've got the discretion, but based upon the facts, I'm going to go this way. Then that means that, and if you acted that way, then you're within your discretion. So you've not acted with fraud or malice. So that's why, again, it's important to know if you're under discretion or if you're under mandatory. If it was mandatory, then you didn't really have the discretion. So you weren't acting with fraud or malice. Another thing to remember that we will look at is what did your legal counsel advise you? Because they will come to us and say, did you give them any legal counsel? And we'll advise them, yes, we did, here it is. And so if you go against our legal counsel, that can have implications. One, we may say, well, why are we giving you legal counsel if you're not going to follow it, and say we're not going to defend you? But again, if we gave you legal counsel and it was the correct legal counsel, then you're getting a little bit more toward this, well, why did you do it kind of thing. This could be more of an intentional act. So if we give you legal advice, take it very seriously and to kind of decide when you make your decision. So that's, just kind of in a nutshell. But again, you get sued, let us know. Once you're sued, don't sign anything and don't say anything. That's what our office will take care of. Once you get that representation, then we'll take over, and that anything that needs to be stated will be stated through the attorney. So any questions? This went on longer than I thought it was going to go. Sorry about that.
Questions. If anybody has questions, what would be the correct process, Janet, for us to forward them to you?
Have an open meeting and go into executive session if you want legal advice. I can't give legal advice through emails.
Okay, I got it. Okay, thank you. Does anybody have any
I'm saying
questions?
if it's specific about something, that's fine. When I say if we have questions, it may be something that needs to be discussed more in open, because that would be a part of the training. The training is open meeting. And so that's why I hesitate to say don't. It's probably best to have another open meeting to go through that.
Okay, so if we need to follow up, if anybody has any questions and we need to follow up at our next advisory committee meeting, we'll let you know if we need you to attend to answer those questions.
Okay.
And you provided a terrific 22-page document that we have that really frames what you've talked about is helpful. I think we can probably turn to that first for any information that we might be looking for.
Okay, that sounds good.
Thank you so much for your time in preparing this training and presenting it to us.
Okay, you're welcome. It's nice seeing everyone. Didn't meet you, but it was nice seeing you.
Well,
I've got you on on one screen and my other stuff on another screen, so I keep looking back and forth.
sure. Thank you.
Uh-huh.
Okay. So the next thing we have on our agenda is executive session. We have an executive session that needs to be called.
Madam Chair,
Yes.
pursuant to KSA 75-4319, I move that the Professional Counsel Advisory Committee recess into executive session for how long?
How long, Jane? Any ideas?
Probably 15, 20 minutes.
For 20 minutes and reconvene the open meeting at 12 p.m. or AM. It's okay. The meeting will be reconvened remotely by conference call at 1-877-278-8686 PIN 327072 and at the link to the board's YouTube channel as stated in the notice of meeting that was sent to individuals who requested notice and published on the board's website, ksbsrb.kansas.gov. The justification is consultation that would be deemed privileged in the attorney-client relationship with the board's legal counsel, Assistant Attorney General Jan Arndt and Lane Bernard. The subjects to be discussed in the executive session concern the Kansas Open Meetings Act during the disaster emergency declaration. Board staff who are included as a client in the executive session are David Fry and Leslie Allen.
Do I need a second for that?
I so move, Elaine Potacek.
Thank you, Elaine Potacek. All in favor? Say aye.
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 Any opposed?
Hey, this is Kenton. I'm still on the phone because I haven't, but is the PIN that he gave the correct one? Because that's not the one that David sent out, I don't think.
Ashley's sending it out now.
Yep, I can clarify. So the email with the PIN number is for the executive session. So that information is not given out publicly. So that information for the executive session was mailed out to the members of the committee at about 4:26 on Friday.
Right. Right. Okay. So I think the PIN that I have from you starts with a 5.
That's correct.
Is that correct? Okay. Okay. I just wanted to be sure.
And just to let the members know too, there are 2 documents concerning the executive session that are emailed out to you right now. So you should be receiving those either right now or in about a minute. And when the executive session begins, I'll go ahead and put everyone from the meeting into the waiting room. So then when the executive session ends, I'll just let you all back in here to the Zoom meeting.
Great, thank you. Okay, so we're going there now?
Yes.
Okay, thank you. See you on the phone.
Number to join your conference. You have chosen not to join the conference. Goodbye.
I enter the PIN number and I get a message saying you've chosen not to join the conference. Could you hear me, Dave?
Oh, hold on 1 second.
Let me just put everybody in the waiting room. Okay, could you turn your camera off?
You want me to mute it again?
Yeah, that's good.
I feel that I just thought about it. I just don't want to.
If they were, it wouldn't have started doing that.
Oh, well, then. Did you need me for anything?
I was gonna ask if I can meet with both of you afterwards. Out of the meeting.
Never.
Never.
Just kidding. How long is the meeting?
Hopefully not even an hour.
Okay. That should be fun then.
If not, it's okay. Just leave.
Leslie, could you unmute yours?
I would say I can go ahead and speak because then I'll just need help with the wording of that email. And then the rest of them I'm gonna put on.
Okay.
Okay, we're all back.
I believe everyone is back. And Laura, I wanted to let you know as well, Leslie Seawester joined during the training. So
Yeah, thank you. Okay, so let's move on to agenda item number 3, approving minutes from last meeting. Our last meeting was in December 7th. I hope you all have a copy of those minutes. Does anybody have any questions about the minutes, or do we need to make any changes before we make a motion to adopt?
Nation conference. Please hold while we place you into your conference.
There we go. Anybody on there?
Yep, this is Kenton.
I can. Okay, so item number 3 is adoption of minutes from last meeting. So you all have a copy. You were sent a copy from, I think Leslie sent those out. Does anybody have any questions about the minutes? And if not, we'll need a motion to adopt the minutes. Any questions about those?
And I'll move that we adopt the minutes.
Okay, need a second? Someone second that?
Second.
So Gary seconds. So all in favor, say aye.
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 Any opposed, say nay. Okay, we have no nays, so the minutes have been adopted. So now we will move to the executive director's report. So Dave, go ahead.
Okay, and in the interest of time, I'll try to go pretty quick here. We are getting into the beginning stages of the legislative session. So since the last advisory committee meeting, the board did meet twice and finalize their positions in terms of statutory changes to be put in legislation. And Leslie and I had a few meetings with Scott Abbott from the Advisor of Statutes office. So the bill draft is complete and we have submitted it for assignment of a House bill and a Senate bill number. Last week, I did approach the House Health and Human Services Committee and the Senate Public Health and Welfare Committee and made formal bill introduction requests in front of each of those committees, which were approved. So like I said, we're just waiting for those bill numbers to come out. It is an identical bill, but basically in the conversations that I had, it sounds like the legislature might want to move pretty fast, or there were concerns that a committee might have to go on hiatus because of the pandemic. So this allows us to get the bill in on both the House and Senate side, whichever one wants to jump on it first. So, and then in terms of budgets, I was informed that the legislature is beginning budget hearings on agency budgets this week. The budget for the BSRB is actually being heard in front of the House Higher Education Budget Committee tomorrow at 1:30. So I've submitted testimony on behalf of the agency and I'll be testifying in front of that committee tomorrow at 1:30. On the Senate side, I haven't received a date yet for when the Senate subcommittee is going to hear the budget, but similar process, they're going to review, make recommendations, and then their recommendations go to the Senate Ways and Means Committee. On the budget side for the House, it goes on to the House Appropriations Committee, and then once it's reported out, we'll go from there. In terms of our internal processes, we are still reviewing a lot of licensees' requests and investigating complaints. The state has indicated to me they're moving towards soft phone technology, which would allow our staff to be able to make phone calls using their computers, but that technology is still a little bit away. We're trying to see if we can move something faster to allow more better customer service. And then just in case you have any questions, about 2 weeks ago, there were concerns about the federal inauguration. So our building was actually shut down for the majority of a week. Our staff was able to work remotely from home. Thankfully, from what I could see, there weren't any issues in terms of any kind of violence or disruptions at the Capitol, but it was a precautionary measure. And so if you had questions about that, I wanted to let you know how that all turned out. So
Great.
Thank you.
Great. Thank you so much for that report. I'm glad everything was safe, but we were all thinking about you. Okay, so updates from the last board meeting. So the last board meeting was on January 11th. And here's some of the things that we were discussing at that board meeting. We continued to discuss the supervisor frequency requirements. And so although we're getting close to really agreeing on them, we're still doing a little more research. Leslie, you are looking at how other states are, I'm talking about Leslie Allen. Leslie Allen is looking at how other states require supervision. And if anybody has any information on how other states do it, please forward that to Leslie. She is doing her research, but if you have any of that already gathered, let her know. It'll save her some time. Leslie, is there anything else you want to add about that?
No, we're just looking at how often other states require how often to meet and the length of the sessions, if they have any specifics. And we're doing it for all the professions except behavior analysts and doctorate level psychologists.
Okay. Thank you. Yes. So if you have anything, please send it to her. It'll help her further her work. And then you were going to speak about the in-residence language, Leslie?
The board is looking at the in-residence as it refers to in the education regulation, which is at the institution with core faculty and for 30 semester hours and for you. And we're going to send out an invitation to the educators. So this is, I'll let you know ahead of time, that the board is requesting that the educators send public comment on how that would affect education now and whether it's I guess, positive or negative going to more online learning.
Got it. Okay. And do you know when that discussion will take place? Do you have a time frame?
Meeting the second Monday in March.
Okay, second Monday in March. Okay, great. Thank you. And then David, you are going to talk about temporary permit statutory language.
Yes, so the board did recommend some changes to the temporary out-of-state permits in statute. Those were limited to about 15 days of in-state practice. The board recommended changing the number of in-state days of practice for out-of-state practitioners to 30 days. Currently in statute, it says those end on December 31st in the year for which they are approved. The board recommended changing that to basically have them expire a year after they are approved. It would also, the board recommended requiring those individuals to have practiced 2 years prior in their jurisdiction, and clarified that an individual may request a temporary out-of-state permit to be extended for one additional 12-month time period. And that would enable the person to get 30 additional days of in-state practice, but that would require emergency circumstances as defined by the board and also the additional fee. There is a fee per year that you have one of these temporary out-of-state permits. And then currently there's no language in there concerning reports to keep track of which days are being practiced. So the language was recommended to be added that would require quarterly reports on the number of days practiced in terms of in-state practice. So those adjustments are included in the draft legislation that has been submitted to the legislature.
Great, thank you. The next thing we're going to talk about, and we're not going to take a lot of time to talk about it today because in the interest of time, we want to really stay to, what we had blocked out for our time. I'd like to ask that at the next advisory committee meeting, for each of you to bring the work that you'd like to see take place this year. I mean, I know we already have, application reviews and program reviews, but really the other things that you'd really like to see happen. You're out in the field with programs, and so you know better than I do certainly what you really feel needs to take place. So I'd just like you to bring your ideas to our next meeting, and when we meet, we will start discussing them. the most impactful things you can think about. So please bring those. Does anybody have any questions or feedback about what we've talked about so far?
Laura, I have a question.
Yes.
On the stuff we've been discussing related to like telephonic supervision and reducing hours, lumping in the 50-hour supervision to be virtual. Were those all, were those all regulation or statute changes? And where do we stand on all of those right now? We've had a lot of conversations, but I'm not quite sure where we stand on where those are in the pipeline.
So I'm going to lean to Leslie and ask her. I assume she knows.
I was going to say, if you need me to, I will. So the statute, the legislative package includes lowering the number from 4,000 to 3,000 and 150 to 100. And it also allows all it says supervision shall all be face-to-face unless there are extenuating circumstances, and at that time, telephonic services can be used. And then in the regulation, which we're doing, whether or not it lowers the number, is the telephonic supervision and the frequency. And that's one of the reasons it hasn't gone through yet, is the frequency and how long each session takes. That's all in regulation. And we're also doing the definition regulation, which includes client contact done telephonically, so that both the client contact and the supervision can be done telephonically.
So let me make sure I understand. So with the statute piece, that's requesting the 4,000 down to 3,000 for total hours, 150 hours of supervision down to 100. And then when you said also that it will allow supervision to be face-to-face, unless there are, extenuating circumstances, face-to-face being defined as virtual face-to-face like this, not same physical presence, like same physical space, correct?
Right.
So in that case, okay.
The statute currently says person to person, and while it may be taken that way, it's not, very
right.
So yeah, this will just make it clear that it could be either or.
Okay. All right, thank you.
You're welcome.
Anyone else? Okay. So our next meeting will be March 1st at 10 a.m. And that's the meeting where I'll be really asking for feedback about planning, the rest of the work that we need to do for the rest of the year. If anybody has any other agenda items that they need to add, please let me know.
Laura, just one more brief question. Are we not allowed to ask what we're allowed to talk about during this meeting until the board attorney's back with us next time? Like, I guess I'm confused what we're allowed to talk about from meetings, what we're not. Are we supposed to never talk about anything, even if it's in open meeting time, or how does this work? Or when are we allowed to ask what we're allowed to talk about?
If you want to discuss what was talked about in executive session or any then you need to wait until the attorney is present and maybe go back into session. But if it's other items, then you can talk anytime.
Okay, yeah, it's not about executive session. It mainly is about like when we talk about changes that we're proposing and ideas for regulation and statute and things that we normally talk about in open meeting. After our meetings, is that all still confidential? We're not supposed to talk about any of that stuff with anybody. We're not supposed to say like, these are things that are being worked on, like they're being considered, or wait till bills are pushed out, or are we?
No, anything you say in the open meeting is fine.
Okay.
To talk about, you just can't talk about it together.
Gotcha. Okay.
In the open, because it's open, it'll be in the minutes too.
That's what I thought, but I just want to make sure I wasn't confused by something that Janet was saying. So
thank you for clarifying that. We can all hear it again and again. So thank you for that. Thank you. So again, our next meeting will be March 1st at 10 a.m. And if you have any questions about that meeting or you want to share anything, get it on the agenda, just be sure and let me know. And then it sounds like it's time for adjournment. So I need a motion to adjourn.
So moved.
Bob's moving. He's just not letting us hear him say it. So
We read his lip. So Bob Kircher makes a motion, and I need a second for that motion, please.
I'll second that, Elaine.
Thank you, Elaine Potachik. All in favor, say aye.
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 Any, I'm sorry, what were you going to say?
He said aye.
Oh, there was another aye. All opposed, say nay. Okay, the meeting is adjourned. Thank you so much for your time.
Thank you.
Thank you.
Thanks.
You all, bye-bye.
Thank you.